Hi, this is disability lawyer David Brannen, founder and managing lawyer here at Resolute Legal Disability Lawyers. In this video, I'm going to talk to you about what is the deadline for applying for workers' compensation benefits from the workers' compensation program in Nova Scotia. So after watching this video, you'll have a good idea. In fact, you'll know exactly what the deadlines are for applying, and hopefully it'll give you some peace of mind and you can take some action on the case that you're worried about. Now, if you like this video, please hit that like button. Don't forget to subscribe, leave your comments, and watch for our videos that come out a few times a week. So what is the deadline to apply for workers' compensation benefits in Nova Scotia after you've suffered a workplace injury or have a medical condition that was caused by the workplace? Now, it's not easy to find an answer for this, as it turns out. If you look at the website for Workers' Compensation Board Nova Scotia, it's not really clear on what the deadlines are. There's some mention that the employers need to report the workplace injury within 5 days of learning about it, either being told by the employee or learning about it in other ways. So there is this idea that there's a 5-day, but I find a lot of people think that that is the actual deadline. If you miss the 5 days, you're kind of ruined. That is not the case at all. So there is this idea of a 5-day reporting period, at which point there is an expectation from workers' compensation that they want to hear about injuries within 5 days. And they put the most pressure on the employer to be the one to report that. So I would encourage you, make sure you try to meet that 5 days or as soon as thereafter. But absolutely, you should be telling your employer immediately and having some type of paper trail record, either a text, an email, or put it in writing in an old-fashioned letter. If it's a conversation, at least write it down in somewhere that you can keep track, that you have a record that you wrote it down, that you spoke to them on this date, and here's what you told them, and here's the person. You need some kind of paper trail there to protect yourself. Now, after you notify them, there is a duty on the employer to report this into workers' compensation within 5 days. Employers do not like reporting these things in. It causes their rates to go up, and it causes them to have to pay more money for this insurance for the workers' compensation. So employers, some of them will try to do everything possible to discourage you or to say maybe this wasn't a workplace injury, or maybe you should just be doing this through insurance, through short-term disability or EI or something like that. You need to make sure you have the conversation with them and report the injury. If they take this view that they're not going to report it or whatever, there's not much you can do about that other than report it yourself, which I'm going to advocate that you do, but you need to report it to them. So once it's reported to them, how long do you actually have to get a claim in, to report a claim in to workers' compensation that they will still accept it? The answer is you have a year from the date of the injury or from the date when you first learned that you have this work-related medical condition. That's, if it's not an injury, if it's from, you're breathing toxic fumes and now you realize you have this problem. As soon as you learn that this was a problem, you have a year from that date, but it's usually going to be a year from the date of the accident or injury. So you have a year. Within that year, if you can report this directly to workers' compensation yourself, you can go to a doctor and they have forms they can fill out. And most doctors have these forms already in their office. They just fill out the workers' comp form, send it in, and then workers' compensation will hear from you. You have a year. I don't recommend you wait a year. Just because you have a year doesn't mean you wait a year. The sooner you do these claims, the better. Even if you think that it's minor, you're not going to miss much time from work, you might not miss any time from work, still get the claim in. The problem with workers' compensation is, as the injured person, is you're always fighting this battle to prove that the problems you're claiming that are affecting your work were actually caused by a workplace injury and not something else. That's how these cases are usually lost. They try to muddy the waters, or you can't prove it's work-related. When you wait a long time to make a claim or report a claim, it looks more dubious that this is actually something else. And you're going to be fighting that. So it's critical that you get these claims in early. There's a lot of pressure on you. There'll be pressure on you sometimes from many sources not to put in a claim. It can come from a union, it can come from your employer. You just may be embarrassed and not want to do the paperwork, but I'm telling you, get the claim in early, even if it doesn't go anywhere, because you'll be protecting yourself down the road if this thing gets worse. They won't be able to use this excuse that you didn't report it because this is something else. What happens if you miss the year? Well, all is not lost. If you miss the year, there is still a period of time between after the year where the workers' compensation has some discretion to still allow your claim to go forward if you have good reasons for the delay and there's not a real prejudice to the employer, meaning like your delay has made it impossible for them now to defend your claim. That's not usually the case, but that's what they're going to look at. Like, how badly does your delay hurt the ability of the employer to defend this claim? If there's really no hurt to their ability to defend it, and you have some reasons for the delay that are somewhat reasonable, including pressure from the employer is one of them, then you'll often be granted an extension. They're not trying necessarily just to cut off everybody on a technical reason, but you have to have some good reasons for the delay, and it can't really be super hurtful to the employer that you did this delay. Now, here's one of the things. In New Brunswick, it's different. There's no hard limit. Like, they can go as far, you can come in many years later and they will always just look at the circumstances. However, in Nova Scotia, and we're talking about Nova Scotia in this video, it is different. There's actually, within the Workers' Compensation Act, there is a hard deadline here of 5 years. So if you are 5 or more years late, you're done. They can't even consider it. They won't look at it. So if you're over 5 years, then you're going to be deemed too late. And they don't have discretion. If this is the first time you're reporting it, is past 5 years, they won't look at it. This is why you should always get legal advice on this, because there have been cases, and there was a case in Nova Scotia not that long ago where somebody applied after the 5 years, but they were able to be successful because they were able to prove that they actually gave notice before the 5 years. Even though they are formally now making this claim after the 5 years, they sort of made the claim before because they made a claim for other things, and this was sort of included in it, although not really. And so it got overturned, and they were actually found to have been met the 5 year thing because they had actually given notice. They had made a bunch of workers' comp claims. So they were basically saying, look, everybody kind of had notice of this before, and you had these other claims going on, and this was sort of wrapped up in that, so we're going to let you out on this one. You shouldn't try to rely on that, because if it's the first time you're reporting anything and it's after 5 years, you're done. But if you've had other claims that are related to this claim that you're now making, that is somewhat of a new claim, but not really, then it's possible you can even make it after the 5 years. So this is why you want to get advice on this. But I would advise you that if you were past a year, you really should get advice no matter what, because how you present this is going to be critical, because you have to present it in a way that shows that you were reasonable for waiting. You may not know all the factors they're going to look at, so it's important how you characterize this and what information you give as part of your claim to justify why they should allow it, even though you're past a year. Now, you can get that advice from a law firm like us. In Nova Scotia, there's also the Workers Advocates, which is a free clinic that's available to workers who have injuries, and they can give that advice in some cases as well. So there's options there. But you definitely should get advice on how to move forward before you're filing this late claim, because there's a lot going to be riding on it to make sure you present it the right way. Now, if you like this video, hit that like button. Don't forget to subscribe. We'll see you back here next time. Take care.